Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have some breaking news for you in the matter styled as Steve Goncalves et al. Versus Washington State University, which has been pending in federal court in the Western District of Washington. Today, the 11th of February 2026, the Washington State University filed its answer and affirmative defenses to the complaint for damages filed by plaintiffs. If you pull down its document number 16 on the federal docket, which you see in almost every answer to a complaint, whether federal or state, where the defense will either admit, deny, or state it is without knowledge, meaning it doesn't have enough information to be able to respond either way, either admitted or denied, to all of the factual allegations that the defense has been lodged with. However, there is an interesting affirmative defense that I wanted to bring to your attention. If you go to page number 48 of 51, they're raising their defenses in addition to responding to each and every factual allegation. Now WSU turns around in section 10, page 48, and raises a number of affirmative defenses. And this first one is rather interesting. It says here, by way of further answer and first affirmative defense, defendant alleges that plaintiff's damages and or injuries, if any, were caused by the fault of a non-party, meaning someone who is not before the court in this complaint. The parties are the four plaintiffs who are representing as personal representatives for their children. The other party on the defense side is Washington State University. Brian Kohberger is not a party. He is a non-party to this action. So what they're saying here, affirmative defense number one, by way of further answer and first affirmative defense, defendant alleges that plaintiff's damages and or injuries, if any, were caused by the fault of a non-party for purposes of, and then the statute is stated here, including but not limited to Brian Kohberger and or other individuals, entities that may become apparent through ongoing investigation and discovery. Defendant reserves the right to identify additional individuals, entities in this matter. So it appears what the defense is saying here is, first off, if you have any damages, they were caused for purposes of the statute by, not us, the fault of at least one non-party, including but not limited to Mr. Kohberger. And then and or other individuals, entities that may become apparent through ongoing investigation and discovery. It's unclear what ongoing investigation is stated here. Is he talking ongoing investigation within this case? Talking about ongoing investigation by law enforcement? It is unclear. Now, discovery is a completely different matter. Discovery is something that is a civil tool that will happen in this case. It can include such things as taking of depositions, serving of what's called interrogatories, which call for answers to various questions made under oath or by declaration. It could be request for production of documents that one side believes is in the other side's possession, custody, or control. It could be request for admissions. Admit that X, yes or no. Admit that Y, yes or no. Each side will serve discovery in order to get evidence to help them either defend their case, which is what WSU is doing here, or prove their claims, which is what the plaintiff's task will be. There's a number of other affirmative defenses here. Number 8 is stating that the defense alleges plaintiffs have failed to file a claim against the state of Washington as required. This is a pre-suit tort type claim that must be filed against the state. They're saying that it wasn't done properly. They're saying that they did not take measures in another affirmative defense to adequately mitigate, to lessen their damages, again, if any. They're saying that in their sixth affirmative defense, everything that they did was based in good faith in the performance of its duties, and therefore they are immune from suit for matters charged in the complaint. They are also alleging that there is a statute of limitations that has been blown here in the ninth affirmative defense. And finally, they reserve the right to amend its answer to plaintiff's complaint for damages by way of adding additional affirmative defenses and potentially counterclaims as may be warranted by discovery. So they're leaving open the door. Hey, we may come back and add claims against you, plaintiffs, as we get further into the process in discovery. Again, that's when evidence is compiled. Their prayer for relief, they say here, having fully answered the complaint for damages, defendant prays for judgment by the court as follows: for judgment against plaintiffs, dismissing the complaint and the claims with prejudice. Number two, that the court award defendant WSU all costs and reasonable attorney's fees to the extent allowed by law. So they want all of their costs involved. For example, if they have to take a deposition, there's a cost involved. You got to hire a court reporter. You might have to process servers for non-party depositions, for example, and those costs can add up very quickly and get to be very high in federal court. So they want their costs reimbursed. And then they also want their attorney's fees, what it costs to have, even though it's the attorney general, but still they're having to put time aside to defend this case. They want the plaintiffs to pay their attorney's fees. And then for such other relief in favor of defendant and against the plaintiffs that the court deems just and equitable. That's standard language that you see in almost every answer. So, few things learned here. They have denied everything. They have denied that there was any culpability here, that they were negligent, that they violated Title IX in very strong terms in answering to this complaint. They have raised some rather interesting affirmative defenses, left open the possibility that, hey, there may be other third parties or entities out there, along with Mr. Kohberger, who you might want to go after, ladies and gentlemen. They're saying here, potentially statute of limitations is blown. They've said here that they're going to leave open the possibility to turn around and sue the plaintiffs by adding counterclaims in future. And they're also wanting an award of attorney's fees and costs. So they've come out, it looks very strong in their answer and affirmative defenses. We're going to continue to keep you posted as further developments arise. Until next time, this is Kathy. Thank you for joining us here today.